Any mention?
Lordship, I beg to mention item number 3. Lordship, I pray if this matter can come up after vacation, Lordship.
Item 3. On the request made on behalf of the respondent, list this matter after the winter vacation.
Lordship, I have a similar prayer for item number 4.
4 also?
Yes, Lordship.
Who is petitioner 4? You are there. 4 also same order.
Highly obliged.
May we please, Your Lordship? Your Lordship, I beg to make a mention for item number 10, Your Lordship.
Item number?
Number 10.
Then
Lordship, I pray that this matter may come up after vacation, Your Lordship.
no objections.
This is item 10 on the request of the petitioner. Okay. List the matter after
Your
vacation.
Lordship.
Yes, Your Lordship. Lordship, I beg to mention item number 8 on behalf of Sari Khan.
Item number 8.
8, Lordship.
Yes, I inform the state, my lord.
State.
No objection.
After vacation, item 8. You are there?
Lordship.
Any objection to the plan? Item 8. Item 8 on the request of censor after winter vacation. Okay.
Much obliged, Lordship.
Your Lordship, I beg to mention item number 12, 13 and 14. Your Lordship, it's a connected matter. Your Lordship. I pray that the matter may come up after the vacation.
No objection.
13, 14 also on the request of the petitioner.
12, 13.
You are there in both the cases.
I'm in 12.
I mean 13 and 14, my lord.
It's 12, 13 and 14, Your Lordship.
12, 13 and 14.
Yes, Your Lordship.
Okay, all after vacation. On the request. Yes.
Oblige.
Just write the same order.
Oblige.
May it please Your Lordship.
Yes.
Lordship, I beg to make a mention of item 5.
Yes.
No objection, my lord.
Same order. Just say on the request of the petitioner after vacation.
Highly obliged, Lordship. May it please Your Lordship, I beg to mention item number 9. I humbly pray let this matter may come after vacation.
No objection, my lord.
Is it criminal appeal?
Yes.
Criminal appeal.
9. This will be on the request made on behalf of the appellant. Okay. Nice. Just take note of all those things, Mr. Rupa.
Let it come immediately after the opening of the vacation, Your Lordship.
Oh, you were there. You were there in that.
There is a stay of the conviction, Your Lordship.
Is it? Oh, conviction is suspended. There is a
By
suspension of
the
sentence.
lower court, then they filed the appeal.
That was continued.
Wished to suspend.
Okay. We listed immediately after vacation.
Lordship.
Obliged. Please, Your Lordship. Your Lordship, I
Yes.
beg to mention item number 7, Your Lordship. Your Lordship, I pray this matter will come after vacation, Your Lordship.
You were there, Mr. Abraham,
Yes, your lord.
after vacation.
Highly obliged.
7 on the request of London Constitution. Okay.
Supplementary costless. Item number 1.
Please, Your Lordship. Your Lordship, I pray that I may be allowed to withdraw this petition, Your Lordship. With liberty to file afresh.
Why liberty?
Some of the other important documents are required to, which are supposed to be enclosed in this petition, could not be
Okay.
enclosed, Your Lordship.
Lord counsel for the petitioner submits that there exists some defect in the petition which requires to be rectified, and accordingly prays for withdrawal of the same with the liberty to file afresh. Also, prayer allowed. The matter stand dismissed on withdrawal with liberty as straightforward.
Highly obliged. May list. Item number 1.
May please, Lordships.
Yes.
Lordship, respondents are supposed to file their affidavit in opposition in this matter. Mr. P.T. Sangma is for the respondent number
Yes.
2.
For respondent number 2, the state will file.
So for the state, I'll rely on the aberment in the writ petition only, Your Lordship.
Okay. Just say heart so and so, just right. Then your MS, just give your name please. Okay. Honored counsel appearing for the respondent number 2. Please for grant of. How much?
It will come after vacation, Your Lordship.
Still come automatically, go after vacation if it is.
After vacation only.
A grant of 2 weeks time for filing. Everything in opposition in the matter. Clear allowed. In this matter after winter vacation.
Apply, Your Lordship.
Deeply obliged, Lord.
Item number 2.
Yes.
Lordship, we have taken steps with regard to respondent to. With regard to respondent, we
How
have,
do you say I hear less?
with regard to respondent to, we have taken steps, Lordship, and the service is affected.
Then
Lordship.
what happened? Okay, yes, the ID card has received. Anyone appearing for respondent number 2? It looks like it has been received.
Lordship.
Who is respondent number 2?
The HDFC Bank, Your Lordship.
What is this matter about?
This is regarding their bank account has been frozen.
yes. Freezing of
So,
account.
Yes, so they have prayed for defreezing the account, Your Lordship. I just need some more time to
That
get
is all right.
instructions.
Just we are on just appearance. Right now we are on
Correct, Your
appearance
Lordship.
also.
Yes.
Okay.
We'll be filing the affidavit
Office-
of service, Lordship. Service of affidavit will be filing.
No, it is already said, sir, that is what it says. So no service affidavit is needed.
No one has appeared.
You have seen the office note. Have you checked it? No, you have not checked it.
It's
You should check it.
affected on
Always service things and all. Before you make a submission, you should always see office note and then you will make submission. Okay. Has been received. That is what they say. Okay. Office note dated 7/2023 indicates that the respondent number notice upon respondent number 2 has been duly served. However, none appears for the said respondent when the matter was called out. MST Yangi, learned AG, appearing with MSI Lingua, prays for grant of some time for obtaining necessary instruction in the matter.
Instructions and affidavit.
Prayer allowed. This is a matter after vacation.
Obliged.
obliged.
Instructions. Okay. They have changed the name to November.
Hearing. Item number 6.
Yes, who is there?
Number 6.
Yes, Mr. Qureshi. What is the matter about?
Lordship, the case was in fact disposed of by the Supreme Court on the basis of the inquiry conducted.
What is this? What is the subject matter here?
The subject matter is very simple. My case actually, this case should not be reopened. There is a SSA, under the SSA, there are 3 teachers: science teacher, language teacher, and social studies teacher. I am the social studies teacher. I was not paid the salary. Then I filed read petitions before this court. My prayer is very limited. My prayer is to, if I read my prayers, under these circumstances, it is therefore prayed that your lordship would be pleased to admit the petition, call for the record, issue notice calling upon the respondent to show cause as to why the writ of mandamus or any other such writ should be direction be issued, directing the respondent to release the salary of the petitioner with effect from April 2018 till date.
This is what school? Aided school?
It is under the SSA. SSA school.
The salary is paid by the government for sanctioned posts.
In this case,
salary is paid by the government.
In this case, admitted position is that I am the social studies teacher, and as per the affidavit filed by the government also, there is a very limited prayer in this case. But salary was withheld by the department, saying that there was some litigation is going on between two parties, Mosamara Begum or Samuel Haq. They were having litigations, and because of that reason, the issue of salary was stopped. The court said, let me call for the inquiry report from the directors. Directors submitted inquiry report, clarified that I am the social studies teacher, and one Samuel Islam is the language teacher. There is a two dispute only. Then here the case was disposed of on the basis of the inquiry, and they are not disputing my post. Now case is disposed of. Then I think the Mosamara Begum filed an appeal before the
private respondent. There are respondent number 6 is managing committee.
Managing committee.
You are there, Mr. Shangreshu.
Managing committee is Samuel Islam. Samuel Islam is the managing committee.
Managing committee is just number 6. Number 7 is
7 is the newly pleaded respondent.
Moshomira
Begum.
You know, my submission is that the relief will be granted in terms of the prayer made in the petitions. And my pleaded case is simple, that I am a social studies teacher and I am entitled to get the salary which is withheld.
Why respondent number 7 has been implemented?
That's what. Then after the inquiry report submitted, stating the status of the teacher, about me, they said social studies teacher, no dispute. There is no dispute. Nobody is claiming my post also. There is a one post, language teacher. There is a claim and counterclaim. Samuel Islam saying, I am the language teacher. Mosamara Begum saying, I am the language teacher. After the inquiry, the court has disposed of the matter. Said on the basis of the inquiry submitted, it is very clarified that who is the language teacher and social studies teacher. I think the Mosamara Begum went to the appeal. He said, I was not heard in this case. But here I am a dominus latis because I am not required to.
What is the order passed by the earlier round of litigation?
The order pass.
Order pass is order dated 25.
The court has to get the fact. You see, the court is not getting the fact properly.
Order dated 25.
You are a teacher of social studies. There is no dispute with regard to your teacher.
To my post. Yes.
Two other person fighting with regard to some other post.
Samuel Islam.
But then you have been made to suffer. Is it the case?
Yes. And this case
is it as simple as that?
Actually, this case would not have been reopened.
Teachers are
reopened because suppose if there is inquiry report submitted by the directors, the Mosamara Begum could have filed a separate petition challenging the inquiry report, but not to reopen my case.
Forget about Mosamara Begum. Just tell about your case first. We'll come to Mosamara
my
Begum
case
later.
is nothing because my grievances redress.
Just tell what is there anything impugned in this thing? No, nothing has been impugned. Now your salary has been stopped.
Stopped now. It is
now from
the government started paying salary.
Has it been stopped by any order?
No order.
Then who has stopped paying? The government or the managing committee?
This is the government has stopped, saying that there was some litigation going on between the two parties.
Where is that order? Where is that?
But government had not passed any order also.
So what is the stand taken by the government in this matter?
Government stand taken by the government is that government is saying Abhinay Samuel Islam is a language teacher. It is their dispute, not my dispute. To me, a social studies teacher.
No. What is the stand taken by them with regard to non-payment of your salary?
Non-payment of salary.
I'm sorry to the check. With the paying for number 6, this is PTCA council. He has gone for months later to prepare the case. Number of time I don't either one thing, the absence, two other things, the absence going on.
Senior counsel Siddiqui is required in this case because the fight is between.
Next week we will not keep.
After vacation.
Already there are some matters. If we hear it, we will not have chance to dispose it. So if we don't dispose it, hearing becomes useless. If it is urgent today, then it will go after vacation.
But it would be better if he filed a separate application because he has got a judgment in his favor.
The court has not got the picture till now. We have to see what stand government takes. Okay.
So far, Mosamara Begum says the London single just passed the judgment in my favor. Then the Samuel Islam they filed an appeal, writ appeal, which is decided in
no, if it is concerning some other post, then why this
why I have been dragged? My case
material so far as for your case. Anyway, we'll just say A request has been made on behalf of the respondent number 6 on the ground that the senior counsel appearing for the London senior counsel appearing for the site respondent is indisposed. For adjourning the, what you say, a request has been made on behalf of the yes, to adjourn the matter. Come on. Adjourn the matter, stop. The prayer has not been opposed by the land council or the petitioner. Accordingly, list this matter after vacation.
Item number 11.
It was interesting case. Whether 482 inherent power of this court overrides any other law. Because the wording in 482 is very clear. Any court.
Now, what that any court would mean, that is the main thing. So any court under...
Any court. Any criminal court.
Now, whether juvenile justice board can be regarded as a criminal court. If you see the definition of court provided in justice court, it refers only to civil court. The courts which have jurisdiction to grant guardianship and all those things. Otherwise, no other definition of court is provided.
But here they are
Board
against
is not defined that way. Board only says a body constituted under section such and such.
It will be interesting.
These are definitely interesting.
Lordship, I have argued this matter at length in the past. Now,
well, that is another juvenile matter. Teacher, yes.
This is regarding the teacher. Whether a teacher...
Court has forgotten your things. It referred to section 11, section 214.
Let me start again, right from the synopsis point of view.
Yeah, you are ready, mister? You are ready?
Here the court
to answer. It's okay.
This court wanted to know in the past whether a teacher disciplining a student will be penalized under the GG Act. That's the limited query of this court. If yes, then my entire case falls through. If no, then I have a very strong case because two sections have been charged. Section 323 of the IPC.
But by limitation.
Followed by section 75 and section 82. Originally, when the trial court was hearing the matter, they have decided to frame charge under section 323 IPC, read with section 75 and section 82 of the GJ Act. This matter went up on appeal before the lower appellate court, session court. The Leonard Session Court was also of the view that there is prima facie case and have passed an order holding that except section 82, the charge can be framed, prima facie case under section 323 and section 75 is.
Was there any finding by the session court with regard to the applicability of JJ Act?
No. The court has totally ignored the submission of the counsel and have gone on another angle altogether. It is for that reason I have come before this court under the inherent powers of the court under section 482. My case is very simple. I say that the student in question, a class 2 student, happened or didn't happen. We say that the provision of the GJ Act is not at all attracted to a teacher disciplining the student. I have done a lot of research on this. There are many decisions on this saying that a teacher disciplining a student will fall under the exception of section 88 and 89 of the Indian Penal Code. Your Honor will want to read.
Meaning thereby?
Yes.
That I being a major, if I go and assault a minor on the roadside, I cannot be charged under the JJ Act.
I'm speaking exclusively with reference to a teacher disciplining a student. Now when we talk about
what difference
in any other cases,
what is the difference between, in this say supposing this kind of matter, what would be the difference between a normal person and the teacher? How do they stand in a different pedestal? Like
it's different pedestal altogether.
Where is
Suppose
the distinction? Where do you get that distinction?
I will come to that, Your Honor. Suppose I beat a child on the road. I'll be liable under the various provisions of the Indian Penal Code.
Not JJ.
not JJ Act. Suppose I do that. But if I happen to be head of an institution covered by JJ Act, if I do something which I discipline a child, then in that case those exemptions under section 88 and 89 of the Indian Penal Code is not applicable to me. Not applicable. I'll be liable under section 75 or 82.
You cannot be liable under both the things. Your liability cannot be fixed under both the things. Say supposing, do you want to say that if you are charged under IPC, then you cannot be charged under JJ Act?
As a teacher.
Otherwise, say normally.
Normally also.
It is my case or your case.
Yes.
We commit the crime.
Yes.
Then can we be charged under JJ Act? And if we are charged under JJ Act, can't we be charged under IPC?
No.
At the same time.
No. What I'm trying to say, if I'm a normal person, I beat a child. Forget about parents. Parents also fall under the exception of section 88 and 89 of the IPC. Forget the parents. I'm talking about a normal person slapping a child on the road. I'll be liable under the relevant provisions of the Indian Penal Code, penal provisions, but not under JJ Act. That is my simple understanding. But if I'm a head of any institution created under JJ Act, then in that case, the provisions of JJ Act will be attracted towards my any action which is criminal in nature. If I give some corporal punishment to an inmate of a juvenile home, I'll be liable under section 75 and section 82. That's the purpose of this act. Now, I've got a judgment of the Kerala High Court.
Before we come to that thing, can we have a look on the order passed by the session judge?
Oh yes, sir. That is at annexure 3.
Is it a long order?
Not a very long order, Your Honor. Can I come to page 32, Your Honor?
Yes.
Just go to the operative part.
Yes.
This court has also perused the judgments relied upon by the counsel for the appellant, revisionist. The argument advanced by the learned counsel for the appellant, revisionist, regarding non-seizure of the clothes and non-production of photographs are of no significance at the stage of framing charge. When there is medical evidence of injury having been sustained by the victim, the contention raised by the counsel for the appellant respondent regarding delay in lodging of FIR are subject to proof at the time of evidence.
Once appellant respondent, then again appellant revisionist means what? What is that? Any difference? The first line says appellant revisionist. The line which you just read out just now is appellant respondent.
Your Honor, when we look at this court has also perused the judgment relied by the counsel for the appellant revisionist. And
come below then.
The argument advanced by the learned counsel for the appellant revisionist regarding non-seizure of the clothes and non-production of photographs are of no significance at the stage of framing charge when there is no medical evidence of injury having been sustained by the victim. The contention raised by the counsel for the appellant
respondent. Now that is where it's confusing, nothing else. And same party, same. Is it the same?
Yes, sir, same.
There should not be any confusion.
I think there is some type
whatever it is, that is what. You can clarify it because you were there.
Instead of saying accused.
My Lord, if I may assist my senior in this honorable court, my Lord, this is perhaps taken from the cause title of the petition which was filed. Because in page 27 it is very clear, my Lord.
It's all right, no problem. No problem. We are not on this. We do not have confusion, nothing else. That by saying that court should not refer to two different persons, that is what. If you say it is confined to one person, one party, that is all right.
Respondent by mistake.
Because once, in one place it is addressed as revisionist, another place is respondent. So
I
that is
think it should typo error maybe. Just carry on, your lordship. Here, appoint the.
Yes, then? Delay in lodging of see this. There is nothing on the point raised by you. You have not argued that point before that court.
Let me come to that, Your Honor. It is evident from the statement of the victim and complainant that there is no prima facie material of commission of offence under Section 323, that with Section 75 of the Juvenile Justice Care and Protection Act 2015 by the appellant revisionist at the stage of framing charge. The court is only to see if there is prima facie material to frame charge, which this court is of the considered view that the trial court has rightly examined the material on record and concluded that there exists material, prima facie material of commission of an offence under Section 323, read with Section 75 of the Juvenile Justice Care so. As regard the applicability of Section 82 of, this is just it has touch, but not the other argument. Be that as it may, Your Honor. As regard the applicability of Section 82 of the Juvenile Justice Care and Protection of Children Act 2015, it may be stated that the school does not come within the definition of child care institution. This is an observation by the lower appellate court, which this court also perhaps will have to accept. This is the definition, Your Honor. Defined under Section 2, bracket 21 of the Juvenile Justice. As such, Section 82 of the Juvenile Justice Care and Protection of Children Act 2015 is not attracted, and there are no materials to frame charge against the appellant revisionist under Section 82 of the Juvenile Justice Care and Protection so. The order dated passed by so is partly modified to the extent as stated above. Meaning that, as per this decision of the lower appellate court, is that the charge under Section 323 IPC, read with Section 75, be framed, whereas Section 82 is not attracted on the ground that it is not an institution covered by the definition under Section 2, bracket 21. So I have come here on a different take altogether, Your Honor, because this court can examine under 482. I have come here before this court saying that a teacher reprimanding a student by whatever means does not come, it is not an offence attracted under the JJ Act. I have got a decision of the Kerala High Court as well as an article on this subject, Your Honor, which clearly says that there is a flaw in the JJ Act wherein it has not involved a teacher of a school reprimanding. A teacher giving corporal punishment to a student is not attracted in the JJ Act. That article I have got here, Your Honor. It's reported.
This article may not be binding on this court, isn't it?
To assist the court, Your Honor. The job is to assist the court. It is reported.
You are talking about some Kerala High Court judgment. No. Can you see that judgment?
Yes, yes.
If it is now, it's okay. You can carry on. You can later on. You can put it whenever you want. But then, Kerala High Court also on the same issue.
Yes, yes. Kerala High Court is right to the point, Your Honor. Your Honor is having the judgment of the Kerala High Court. So not a very old judgment. It's a
yes.
It's a 2020 judgment, Your Honor.
18 to 20, yes.
I may be permitted to read the entire, right from the beginning, Your Honor, because this is attracted, so far my case is concerned.
If you have the patience to read, there is no problem.
I have, Your Honor, because I am facing trial. I'm an aged person, not a young person or anything. I'm an aged person, I'm facing trial. I've got a reputation, my school is having a reputation, Your Honor. That's why I have to have the patience, Your Honor. The case set up in this criminal miscellaneous case is as follows. The petition.
Give them the citation at least. They will be. They should know the citation. You have given the copy.
Yes, sir. On the last occasion when I. Matthew. Kerala. I have read this judgment on the last occasion. Perhaps this court has forgotten, but they wanted to respond to this. Be that as it may, I continue with my submission. As per, I like to refer to this decision. The petitioner herein was a teacher, music teacher at Assumption High School, Sultan Bathery, Wayanad, having an impeachable and unblemished service record with 30 years of experience. The third respondent is the de facto complainant, meaning the student, Your Honor, who was a student in the same school. The allegation against the petitioner stems from an alleged incident of the petitioner disciplining his student. The allegation against the petitioner herein was that on 27/7/2017, during the last period of the school, at 4 o'clock, the petitioner, under the misunderstanding that his student, the de facto complainant herein, make fun of him by making noise in the open class, discipline him by pinching him under the right arm and smack his head, thereby committing the offence under Section 75 of the Juvenile Justice Care and Protection Act 2015. It is pointed out that the petitioner herein has not committed any offence as alleged, even assuming, not admitting to the same, which is my case also, Your Lordship, that the allegation against the petitioner are true. The same will not stand the scrutiny of law and the various precedents set forth by this court to attract the offence as alleged. In the decision in so and so, Your Honor, had considered the right of a teacher to discipline a student. This was a case wherein a madrasa student had beaten a student, or a madrasa teacher had beaten a student with a cane for creating commotion and showing disobedience to the rules of the school. This court held that when a teacher in course of teaching beats a student bona fide to maintain discipline, no criminal offence is committed as he acted in good faith. It is pointed out that the precedent elucidated shows a protection on the teacher. Further going by the Indian philosophy of Mata Pita Guru Daivam, the teacher is on a higher pedestal than that of God, wherein he has an authority as an imparter of knowledge to mold his disciple into a responsible and decorous citizen. When a teacher in course of teaching beats a student bona fide to maintain discipline, no criminal offence is committed as he acted in good faith. In the instant case, even going by the allegation, not admitting the same, the petitioner was only extending his right entrusted to him under the principle of loco parentis. This is a very important term, loco parentis, as an imparter of knowledge to mold his disciple into a responsible and decorous citizen. The main contention urged by the petitioner are as follows. When a teacher in course of teaching beats a student bona fide to maintain discipline, no criminal offence is committed as he acted in good faith. The alleged act of the petitioner having fallen well within the general exceptions laid down in Chapter 4 of the Indian Penal Code. The alleged act of the petitioner herein are protected by the incredence laid down under Section 79, 80, 88 and 89. See, this is Indian Penal Code. The precedents set forth in various cases, including Abdul Wahid versus State of Kerala, State of Madras, so and so.
Okay, it's okay. You can skip that name.
It is well established that a teacher who, in the course of imparting education, beats a student bona fide to maintain this discipline, that a teacher is given an implied consent by the parents to discipline the people for the welfare of the people. When a teacher in course of teaching beats a student bona fide to maintain discipline, no criminal offence is committed as he acted in good faith. It is in the light of these factual averments and contentions the petitioner has filed the instant criminal under Section 482 with the following prayers. I am here before this court on the same sets of grounds here. Lordship. Number one, I'll not go with this prayer, etc., etc. Now pending so and so. Para 4. Heard Shri Jiku 7 Joyce, learned counsel appearing for the petitioner accused, and Shri T.R. Senjit, learned prosecutor, appearing for official respondent 1 and 3. Though contesting respondent number 3 has been duly served by special messenger, there is no appearance for that party, that is a complainant. It is my case here also, Your Honor. Here also we have made a complainant a party, but they have chosen not to contest here. The main allegation disclosed in the instant Annexure 1 FIR, more particularly the F1 statement appended thereto, is to the effect that the petitioner accused is a music teacher in the school, in which the third respondent minor victim boy is studying, and that during the course of music class, the petitioner accused had pinched on the right arm of the third respondent victim boy and smacked his head. Therefore, the petitioner has committed the above said offence as per section 75 of the GG Act. It is now well settled by a series of ruling, as in so and so, I skip, Your Honor, that in a case where a teacher in the course of imparting education beats a student with bona fide intention to maintain discipline, then as a teacher is given the implied consent by the parent to enforce discipline on the pupil for the welfare of the pupil. It flows from the well-known common law principles of loco parentis. In such a case, it cannot be said that the teacher has committed an offence as per the Indian Penal Code. However, special exemptions are also carved out by the provisions as per section 79, 89, 319 and 95 of the IPC, which read as follows. I will skip this section 79 of the IPC, Your Honor. I'll come to section 89, though it is relevant. Act done in good faith for benefit of child or insane person by or by consent of guardian. Nothing which is done in good faith for the benefit of a person under 12 years of age or of an unsound mind, or by consent either express or implied of the guardian or other person having lawful charge of that person, is an offence by reason of any harm which it may cause, or to be intended by the doer to cause, or to be known by the doer to be likely to cause to the person. The proviso is there, Your Honor. This is under section 89 proviso, Your Honor. First, that this exception shall not extend to the intentional causing of death or to the attempting to cause death. That this exception shall not extend to the doing of anything which the person doing it knows to be likely to cause death. Your Honor, let me skip all these exceptions, Your Honor. I'll come to I'll skip this 319 also, what is hurt and all this. It's not too relevant. Then, now I come to section. Oh, there's urgency. I come to section 75, Your Honor. Punishment for cruelty to child. Whoever having the actual charge of or control over a child assaults, abandons, abuses, exposes, or willfully neglect the child or causes or procures the child to be assaulted, abandoned, abused, exposed, or neglected in a manner likely to cause such child unnecessary mental or physical suffering, shall be punishable with imprisonment for a term which may extend to 3 years, or with fine of 1 lakh, or with both. Provided that in a case it is found that such abandonment of the child by the biological parent is due to circumstances beyond their control. Your Honor, I can skip this. I come back to section 2, bracket 24, Your Honor, the definition part. This is the reproduction of those sections under GG Act, Your Honor. I'll come to section 2, the definition portion, Your Honor. Defines corporal punishment as follows. Corporal punishment means the subjecting of a child by any person to physical punishment that involves the deliberate infliction of pain as retribution for an offense, or for the purpose of disciplining or reforming the child. Section 2 bracket 21 of the GJ Act applies. Child care institution as follows. Child care institution means children home, open shelter, observation home, special home, place of safety, specialized adoption agency, and a fit facility recognized under this Act for providing care and protection to children who are in need of such services. Section 82 of the GJ Act, which deals with corporal punishment, provides as follows. Corporal punishment. Any person in charge of or employed in a child care institution who subject a child to corporal punishment with the aim of disciplining the child shall be liable on the first conviction to a fine of 10,000, and for every subsequent offence shall be liable for imprisonment which may extend to 3 months or a fine or with both. If a person employed in an institution referred to in subsection 1 is convicted of an offence under that subsection, such a person shall also be liable for dismissal from service and shall also be debarred from working directly with children thereafter. In case where any corporal punishment is reported in an institution referred to in subsection 1 and the management of such institution does not cooperate with any inquiry or comply with the orders of the committee or the board or court or state government, the person in charge of the management of the institution shall be liable for punishment with imprisonment for a term not less than 3 years and shall also be liable to fine which may extend to 1 lakh rupees. It can be seen from a mere reading of the above said provisions of GJ Act that the legislature has not made the offence of corporal punishment punishable in terms of section 82 of the GJ Act only if it is inflicted by a person in charge of or employed in a child care institution. The legislature has consciously and guardedly, on account of its legislative wisdom and policy, has mandated that in such a scenario, the act of corporal punishment as envisaged in section 2, clause 24 of the GJ Act is made a punishable offence as per section 82 only. It is a case where the impugned act is done by any person in charge of or employed in a child care institution as envisaged in the above said provisions. Hence, it is clear like day light that the legislature does not make the act of corporal punishment punishable where it is inflicted by a teacher. Your Honor, I have one small submission, and I'd like to continue the submission on Monday, Your Honor.
Next week probably will not have, because we have many matter of weeks. Then in such a case it will go after vacation.
I continue for. I don't have much thing. This decision reading is over. It becomes crystal clear that I have a good case, Your Honor. May I continue for some time, Your Honor?
See, what is the difficulty? You see, Mr. Just tell us.
No issue. I'll continue, Your Honor, for some time. The rationale in excluding the teachers from the purview of section 83 of the GJ Act is presumably on account of the above said well-known common law principles of low parentage. There cannot be any doubt that if the impugned act of the teacher broadly comes within the contours of section 2 bracket 24 of the GJ Act, and thus it satisfies the ingredients of corporal punishment as envisaged in this section. But then the Parliament has specifically excluded the teachers from the purview of punishability of such an act of corporal punishment, as can be seen from the provisions contained in section 82 of the GJ Act. Now, Your Honor, just for a moment, section 82 of the GJ Act is a very, very important provision, Your Honor. If we are to read section 75, it has to be read conjointly with section 82, Your Honor. It cannot be read in isolation. If I am to be guilty of an offence under section 75, then definitely I must be shown to be guilty under the section 82 also, Your Honor. Let me continue, Your Honor.
You want to say that section 75 cannot be read in isolation. It has to be read together with section 82.
100%. Since the impugn action of the teacher in such a case is in pith and substance, which discloses corporal punishment, as per section 2(24) of the JJ Act, and as the said act done by a teacher has been excluded by the Parliament from the purview of section 82, it cannot be said that such teacher can be otherwise roped in within the contours of section 75 of the JJ Act. Of course, if the so-called penal measures taken by the teacher grossly exceeds the permissible proportion of a penal measure that can be taken by a teacher for disciplining the people, and the act otherwise discloses a serious offence as per section 324, grievous hurt or simple hurt, then of course it might stand in a different footing, and those are all matters of questions of fact which have to be assessed in the matrix of the facts and circumstances of each case. In the instant case, the allegation is to the effect that the petitioner, as a music teacher, had pinched the third respondent victim on his right arm and has smacked on his forehead. It cannot be said that the above said act alleged against the petitioner has grossly exceeded the ordinary accepted norms and understanding of penal measure for a pupil by the teacher. It could be that a teacher, music teacher, going by the very nature of profession, might be a little bit over-strict and perfectionist in his approach to teach music, and the act would have been out of what he thought of as necessary to correct the people. And even if some of the ordinary situation had occurred, it cannot be said that in the facts of the case, the petitioner who is a teacher should be roven with the criminal culpability of any of the offences as per the Indian Penal Code, Your Honor. Such an act would be constituted only one that is caused to such an act should be construed as one which is likely to cause any harm, if any, which is so slight that no person of ordinary sense or temper would complain of such harm as envisaged in section 95 of the IPC. However, it cannot be said that such an instant act of the teacher accused is said to be an act of assault, as is envisaged in section 25 of the JJ Act. The term assault has not been defined in JJ Act, Your Honor. Your Honor, I skipped paragraph 8, paragraph 9. This is all the description of the various provisions of IPC. And I come straight to paragraph 11, Your Honor. The above act of the accused as allegation in the FIR cannot be said to be one involving intentional use of force in order to commit an offence or intending by such force to cause or knowing it to be likely that by the use of such force he will cause injury, fear or annoyance to the person to whom the force is used, as envisaged in section 350 of the IPC. Such an act of the accused should predominantly be seen as an act on the part of the teacher to correct the people, which inherent power has been conferred by general law on the teacher by the well-known common law principles of loco parentis. Therefore, it will not be legally correct to contend that such an act of the petitioner accused would constitute an act of assault as envisaged in section 75 of the JJ Act, so as to constitute the ingredients of the said offence. The police has now completed the investigation, which is also in my case, pursuant to the impugned Annexure 1 FIR, and has now filed a final report charge sheet, which is in my case also, in this case as per the impugned Annexure 2, which has led to the pendency of the calendar case, CC numbers also, and the files also. For the offence as per section 75 of the JJ Act. In the light of the above said aspect, this court has no hesitation to hold that the continuation of the impugned criminal proceeding is an abuse of the process of the court, and it is rather very unjust and unfair to make the petitioner face the impugned criminal proceeding. Though notice has been duly served on the third respondent, which is in my case also, who is represented by his father and natural guardian. He has not chosen to appear before this court and contest the case. The complaint would have been given by the third respondent as well out of the heat of the moment. In the light of these aspects, it is ordered that the impugn annexure to so-and-so be quashed. In support, this is a judgment, Your Honor, which there is no other contradicting judgment or judgment which rebut this finding of this court.
Subject to what they say?
And there is an article, Your Honor, on corporal punishment of children in India, and this is it is SEC online, Your Honor. You got that also, no? I've given last time. I'll give you one more copy. I will just come to the relevant page, Your Honor. That is at page 7, not to waste the time of this court.
This court has time enough. That's the problem.
No, not to waste unnecessarily.
Continue in the second half.
I'll come to the. No, I'll continue, Your Honor, for some time. Flaws in the Juvenile Justice Care and Protection Act 2015. The Juvenile Justice Care and Protection Act 2015. Is Your Honor having?
You are reading which part?
Page 7. Flaws in the Juvenile Justice.
Page 7.
Page 7, Your Honor. Page 7, Your Honor.
Yes.
The Juvenile Justice Care and Protection Act 2015 was enacted to protect the children who needs care and children who are in conflict with the law and provide them with basic need, treatment and other rehabilitation services through the various processes and other bodies that have been established. Section 2(9) of the Act defines best interest of the child, and this definition lays down that any decision that is taken for the child must lead to the emotional and intellectual development of the child and must be taken in such a manner that it fulfills the right and interest of the child. Administering corporal punishment is against this very definition. The preamble of the Act states that this Act is enforced concerning children who are in conflict with law and children who require care and protection. And this limits the scope of this Act because the children who are not in the custody of the state or who are not in child care institution, Your Honor will have to highlight this very portion, Your Honor, but who are physically disciplined by their parents or quasi-parents, such as home tutors, are disregarded. According to Section 75, anyone who has actual control of or is in charge of the child, if assault or procures or causes to assault a child, could be held liable and shall be punishable for a term that could extend for so and so, so and so, so and so. I'll continue with the next point, you know. Both the sections avoid from the purview quasi-parents, such as teachers. Section 75 mentions a person who is in charge of a child or actual control. This may include quasi-parents, but then there is a certain sense of ambiguity that exists because quasi-parents, such as tutors or teachers, most obviously do not fall within the ambit of someone in charge or in actual control. Section 82(1) specifically mentions a person that would be employed or in charge of a child care institution, and thus both parents and quasi-parents will not be held liable for inflicting corporal punishment, as this section is limited in its scope. Therefore, we can say that this Act is inherently flawed. The Act seems narrow and seems all-inclusive. Not all children who undergo physical chastisement are children who require special protection or children that are in conflict with law. Irrespective of the circumstances that the child is coming from and irrespective of the degree of corporal punishment that is administered, all sorts of such punishment must be prohibited, and not only in certain settings such as childcare institution as mentioned in section 82 bracket 1, but other settings such as home as well. According to this writer, he says that all children must fall under purview. That means it needs to be amended, Your Honor. Your Honor, I avoid this flaw in the Right to Education Act. I come to next page, page 9, Your Honor, relevant part. Page 9, Your Honor. Scope for defenses in provisions of criminal law. How does it indirectly legitimize corporal punishment, Your Honor? This is a very, very important writing, Your Honor. The various judicial and quasi-judicial authorities have claimed defenses under these sections of the Penal Code 1860. 1860. This further has endorsed the narrative that corporal punishment must be carried out for the best interest of the child and is to bring a sense of reformation in the child. Section 88 of the IPC provides that a person will not be held liable if an act which is not intended to cause death is done with consent, expressed or implied in good faith, and for the benefit of the person on whom the action has been carried out. Section 89 provides that one would not be held liable if an act is carried out in good faith for the benefit of a child under 12 or an innocent person by the guardian or with the consent of the guardian. In the case of Ganesh Chandra Saha versus so-and-so, the school headmaster was acquitted even after the child, who was 12 years of age at the time when the punishment was administered, was caned and was even given fists and blows. The court had held that section 82 and section 88 and section 89 will not be attracted in this case as it was done in good faith, and that the consent of the child or the guardian of the child is implied from the fact that the child was sent to the school, and thus is implied that the child would be under the discipline of the school, and that administration of reasonable punishment is necessary for maintenance of discipline and would benefit the child. The ease with which parents and quasi-parents can claim this defense under criminal law indirectly legitimize corporal punishment, as they put on a garb of acting in good faith and escapes from the liabilities imposed by the law. The parents and quasi-parents justify their actions by claiming the defense that they acted in good faith and the express or implied consent of the guardian or child is misinterpreted. These sections must be revoked or amended so that it is not misused as a defense for physical chastisement, and all-inclusive laws that completely prohibits corporal punishment, irrespective of whether it is moderate or not, must be enforced. Now, Your Honor, that's the end of my submission so far this article is concerned. I have been able to impress upon this Honorable Court by the decision of the Kerala High Court as well as this article, which clearly points out to this fact that there is a flaw in
the fact remains that whether act has been committed in good faith or not, which way to determine? Is it not a subject matter of evidence?
Your Honor will have to limit insofar the finding in today's case is concerned, whether the offence which was charged, section 75 or section 82 of the J Act is attracted or not. We'll have to limit to that. If it says no, then so far as section 323 is concerned, I already have a defense.
You do not have to 323. You do not have to go to 323. Forget about that thing.
Now this court will have to limit whether.
No, just confine yourself to 75. The charge which is remaining after the passing of the order by the session judge. Okay. Now, the contention. If you were to say that JJ Act will not be applicable.
That's the law. That's the precedent. Right,
that if it becomes a general way, so it means like whatever has been, whether you see whatever action is committed by a teacher, okay, even you see that results in causing grievous hurt. This cannot be charged under section 75.
Yes, Your Honor. This is the law.
That is what you want to say.
Because of that section, otherwise, section 88 and section 89 will have to be amended of the IPC.
No, what section 80, what is the section 88, 89, does it put absolute bar?
Yes, that's what I have read just now. That's the exception insofar disciplining a child is concerned.
This is what
whether by
disciplining.
parents.
See, disciplining a child, I don't know which way you read it. Just come to section 88. Something done in good faith. It also speaks of good faith, isn't it? Good faith. The word good faith is attached here. Now, is there any presumption of good faith? Just because the word good faith is attached here, whether the presumption of good faith is automatic in a case involving teacher.
Your Honor, why I'm here? I'm here because I see that I am a teacher. Whether I have done serious harm or not, that's a different issue altogether. What I'm trying to project before this court is whether as a teacher, the offence under section 75 and 82, whether it's attracted so far a teacher is concerned. The precedent that I have cited, Your Honor, clearly says that section 75 and section 82 is not attracted, Your Honor, so far a teacher is concerned. And that article, Your Honor, can disregard it. But the judgment of the Kerala High Court, the only precedent right now, if we are to accept that JJ Act applies to teachers, then in that case, there has to be an amendment of the JJ Act. There has to be an amendment of section 88 and 89 of the IPC. I've already read just now section 88 and section 89. Your Honor.
No, section 88, 89 is
Yeah,
not
the general
confined to the
exceptions.
application of JJ. It speaks about the general offence commission. See, it is irrespective of whether you are charged under JJ Act or any other act. Okay. It says that will not be wrong. Certain action on the part of the teacher will not be taken as offence. That is what section 88, 89 says. It is not specific to section 75, isn't it? Does it?
Pardon, Your Honor? Yeah,
What section 88 speaks? What section 88 reads?
Act not intended to cause death.
Yes.
Done by consent in good faith for person's benefit.
Yes.
Section
So this
89.
will not be regarded an offence. It is not specific to section 75. It will not be an offence if at all there a person can be charged or any other.
The corporal punishment that is defined in the JJ Act is not relatable. So far, the corporal punishment inflicted by a teacher in a school. That's what I'm trying to say, Your Honor. Section 89.
Yes.
Act done in good faith for benefit of child or innocent person by or by consent of guardian. Now, what is my case before this court, Your Honor? I have clearly said in my petition that I'm not exactly going into the merit of the case. I have come here before this
What
court.
is the age of the victim here in this case?
Allowed 7 years.
7 or 8 years. There was an allegation that I slapped. That also I didn't know that I slapped that child because I'm not a teacher of that class. I'm the headmistress of the school. I happen to...
The child had to be given medical attention, medical care.
Yeah, simple injury, something like that. That too after 48 hours. Not immediately. If it would have been immediately, then I would have come to know. I came to know only from social media after, only on the 29th, Your Honor. Only on the 29th. The alleged date of occurrence is 24th of March. Ne? I came to know only on 29th. I have a humble submission before this honorable court.
Yes.
That to limit the answer whether a student who's not an inmate of a childcare institution or under the any institution controlled by the government under the GJ Act, created under GJ Act, whether he comes under the purview of GJ Act, whether the teacher inflicting, disciplining the student comes within the definition of the offence under section of the GJ Act, Your Honor. According to me, I say that I am not, my actions, even if I admitted or not admitted, Your Honor, that I have done something to the child, the section 75 and section 82 of the GJ Act is not attractive. I'm not coming to the other party. My case here is that being a teacher, I cannot be charged under section 75, Your Honor. That's the limit. If Your Honor will.
So in broader sense, you want to say the teacher cannot be subject of GJ Act.
That's what I have. The judgment says.
That is.
Yes, Your Honor.
That is what your contention. Forget all this. Your contention before the court is this, isn't it?
Yes, Your Lordship.
Anything more? Anything you want to say? Anything more?
I pray that the entire proceedings pending before the Judicial Magistrate First Class be quashed, you know, in view of what I have been submitted, in view of the law in place, Your Honor. My credentials I have mentioned in the writ petition. I have been reputed to be a very good teacher. I got a Meghalaya award also. That is my
We are not going into all those things. We are just confining ourselves to the applicability of those things. Do not try to prove your bona fides. That is not required. Because if you go to that,
I'm not a criminal.
Bona fide will be, according to the understanding of the court, is totally subject matter of evidence. We will be simply on the question whether 75.
Yes, no, whether 75 is attracted. So far, in this case is concerned.
Yes.
My Lord, firstly, my Lord, will kindly consider the age of the student.
Just confined to the submission which is made.
Secondly, my Lord, my learned senior has cited a judgment, no doubt, my Lord, and some articles. My Lord will kindly see in this, even in this petition before this honorable court, my Lord, there is no, my Lord, there is no averment stating that whatever act was done by the petitioner, my Lord.
Doesn't matter, Mister. You see, which way it matters? Is it we are not sitting in a writ jurisdiction?
My Lord, just basic facts.
Basic fact means like what relevance it will have. You say
punishment-
something which will be relevant here.
My Lord, as far as-
Whether there is an absence of these things, whether he says I am innocent or not, will not have any.
And as far as the, I'll come step by step, my Lord. As far as the corporal punishment is concerned, my Lord, there is also a notification of the government of Meghalaya, my Lord, which completely bans any form of corporal punishment, my Lord. But that.
No, and if what happens if violation of that is alleged, then where they judge?
My Lord, of course, this notification is issued under the RTA Act, my Lord, the Right to Education Act.
No. Give us the notification, and there is no problem. Just
We are not coming, we are not here under that. My case is completely the opposite of that.
let us see, Mr. Kinta, what he wants to say.
But my Lord, the fact remains is that, my Lord, that no corporate punishment can be given to anyone, any of the student, whether it is in the form of physical or mental. My Lord. It is if it is a teacher of an institution or principal, my Lord, no one has the right to give.
It is for the state of Meghalaya, isn't it?
My Lord, for the state of Meghalaya.
Now the violation of that will basically make a person liable under section 75 of JJ Act.
No, of course, that is different, my Lord.
You argue on that point.
My Lord, as far as section 75 is concerned, my Lord, what it says. My Lord, my respectful submission is that, my Lord, firstly, my Lord, I'll take my Lord to my Lord, section 2, subsection 24, my Lord, of the Juvenile Justice Act.
Of which act? JJ Act.
My Lord, of the Juvenile Justice Act.
Oh, there we go. We'll continue in the second half. Will be all right. This will be all right for you. Or you want it on Monday?
I want to continue on Monday, Your Honor.
But Monday because my lord, I have a lot of matters before Honorable Court number 2, my lord, Justice. Thank you. A bunch of matters, my lord.
Last time they said that, but in fact they had nothing, Your Honor. They asked time here.
My
We
lord,
can adjust. I can accommodate with them any time.
Let us keep it on Monday. Let us keep it on Monday. Let us see.
Yes. We can
In
accommodate.
case you can arrange it, we will have it on Monday.
Mhm.
Otherwise, it will go to some other day for your reply.
Just to respond on that point.
For your reply.
matters are there.
You see, like if you have difficulty, you may not have to come. You can be represented by anybody also. Once you conclude your argument, that is all right. Of course, we do not know whether.
Monday. I can continue second half, Your Honor. I was informed that the urgent matter before Honorable Justice number 2, Court number 2, has been fixed on Monday. I can continue by
second half.
Then let it come on 13th, my lord. Because Monday, my lord, my senior may verify.
Second half today.
Today, my lord. Today is fine.
We'll come back.
Pintu. Ini.
Gone. Item number 15.
Yes. Have you filed any objection? No.
Objection we had not filed, my lord.
Yes, all right.
So, my lord, I draw my lord's attention to the Juvenile Justice Act, my lord, 2015. So I was referring to, my lord,
224.
Yes, my lord. Section 2, subsection 24, my lord. Corporal punishment, my lord, means the subjecting of a child by any person. My lord, that is what it says, my lord. Corporal punishment means the subjecting of a child by any person to physical punishment that involves the deliberate infliction of pain as retribution for an offence or for the purpose of disciplining or reforming the child. My lord, I take my lord to the definition of my lord, best interest of the child, which is subsection 9, my lord, of the same section, section 2. Best interest of child means the basis of any decision taken regarding a child to ensure fulfillment of his basic rights and needs, identity, social well-being, physical, emotional and intellectual development. My lord, then I take, my lord, to the meaning of the child, my lord, which is subsection 12. Yes. Child means means a person who has not completed 18 years of age. My lord, in the instant case, my lord, there was an FIR which was filed by the victim's mother, my lord, which is at annexure 4, page 34, my lord. And typed copy, my lord, is at page 35.
Yes.
My lord, if I may read, my lord. With reference to the subject cited above, I, Srimati Chameli B. Marag, like to inform you that my daughter, Miss Arusa, so and so, aged about 7 years, studying in class 2 in Auroville Higher Secondary School from Tura, so and so, was physically abused. So this is what the FIR says. Physically abused by the headmistress of the Auroville Higher Secondary School, Tura, so and so, dated 24th April 2019 in the school premises. This is for your kind information and necessary action under. So this is provision she has quoted there, madam. 323 IPC section 32 of the CP 2010 and also Juvenile Justice Act, so and so, my lord. Now pursuant to that, my lord, the case was investigated and it was charge sheeted, my lord. Now, my lord, these facts, whatever is submitted before this honorable court, my lord, these facts are also brought to the notice of the honorable trial court, my lord. And the learned trial court, my lord, came to a finding that a case is made out, my lord. So, my lord, the initial order is at, my lord, dated 23. My lord, the first order, my lord, initial order, it is page 18, my lord. The order starts from the next page, my lord, dated 14/1/2022. This was the conclusion of the court. If I am allowed to read the order, my lord.
No, what relevance it will have? This has to be modified by the session judge order. Then?
So, which was, of course, subsequently modified.
What you are trying to say?
So, my lord, the court below has already come to a finding, my lord, that even if section 82 is not very relevant, my lord, but however section 75 of the Juvenile Justice Act remains, my lord. Now this finding is, my lord, at page 33, if I am allowed to read from page 32, my lord.
That has already been read out. Like what you would like to point out from reading of those
my
things?
lord, according to me, my lord, there is no infirmity in this order, my lord. Whatever reasons that have been cited
what is the
by
answer
court below,
to the contention raised on behalf of the petition? What is your answer to all those aspects?
My lord, in my respectful submission, my lord, the contention of the petitioner that these the JJ Act does not apply, my lord, or the rule 75 of the JJ Act does not apply, as well as rule 82, my lord. Even this, I agree to the, my lord, the stand which is taken by the Honorable Court of the Districts and the Court of the Session Judge, my lord, where it says that even though section 82 does not apply, but section 75 of the Juvenile Justice Care and Protection Act, Children Act 2015, that is very much there, my lord.
The contention based on that judgment of that.
Now, if I may take, my lord, to what the section says, my lord. My lord, this is punishment for cruelty, my lord. If I may read it.
No, you are not coming to the issue, you see, like.
My lord.
Address those parts, those points which have been raised on the basis of the judgment of the Kerala High Court.
My lord, as far as the corporeal, my lord, my senior stated that with regard to the corporeal punishment.
Your submission with regard to section 88, 89 of the Penal Code.
My lord, as far as section 89, which is saying act done in good faith for benefit of child or insane person by or by consent of guardian. And my lord, section 88 says act not intended to cause death done by consent in good faith for the person's benefit. My lord, earlier at the beginning, my lord, I had stated, my lord, the petitioner, my lord, nowhere in this petition stated that any of her act, that she acted in bona fide good faith. Now that defense was never taken by the petitioner, my lord. It is not a case, it is nowhere, there is no whisper in this instant petition, my lord, that whether the act which is done by her has been done in good faith, my lord. Now as far as the good faith is concerned, whether it is done or not done in good faith, my lord, that will only be clear in the process of trial, my lord.
Elaborate more on section 224.
My lord.
224 corporal punishment.
Yes.
Now that is some area you may explore. Section 2, subsection 24 of the JJ Act, which you have referred just.
Oh, my lord. My apologies. My lord. Corporal punishment means the subjecting of a child by any person. So, my lord, my respectful submission, any person, my lord, would include.
Definitely, it will include teacher.
My lord.
There is no dispute about it.
My lord.
If it's any person.
Any
But
person
then
to physical
how
punishment.
It is to be read together with section 88 and 89 of the Indian Penal Code. It speaks about corporal punishment. What would constitute corporal punishment?
My lord. Now, my lord, here if I read section 88, my lord, here it has been an illustration has been. If I'm allowed to read the section, my lord, of the IPC, my lord, 88. Act not intended to cause death, done by consent. Now, my lord, the consent is whose consent, my lord? In good faith for person's benefit. Nothing which is not intended to cause death is an offence by reason of any harm which it may cause or be intended.
Yes.
Nothing which is not intended to cause death is an offence by reason of any harm.
How you are reading the contents?
My lord.
Which way? What is that? Like 224 you have read out. Section 2, subsection 24 read out to show what is corporal punishment.
Yes, means subjecting a child.
Yes.
Subjecting of a child by any person to physical punishment.
Yes.
Now it may be any
How
form.
do we read together with that one with this section 88 and 89 of the IPC?
My lord, as far as section 89, we can establish a link, my lord. Here it is said, act done in good faith for benefit of child. For benefit of child or insane person. So either it is a child or insane person.
Now, as per Juvenile Justice Act, even to discipline somebody, even if physical act is done, that will be corporal punishment.
Yes, my lord. This is what the definition says. Means subjecting a child by any person to physical punishment.
You are just reading out those provisions and all. Do you have any case law, anything?
My lord, one case law is there. In fact, two case laws. Other, of course. This is, of course, relating to corporal punishment, my lord. But here, of course, the JJ Act is not mentioned, my lord. Here, the challenge in the Honorable, this is the High Court of Delhi, my lord. Of course, this is from SCC Online. This is against corporal punishment, my lord. There was a provision in the rules which permits corporal punishment, my lord, against which the parents had approached the Honorable High Court, my lord, Delhi High Court, and then it was decided that against the said provisions, my lord.
Very difficult to comprehend what you say.
My lord, kindly goes to the judgment. I'll give you a copy. I'll give a copy to my senior also, my lord. Because due to paucity of time, I have just taken 2 copies.
Given that.
But this is Parents Forum for Meaningful Education and another versus Union of India and another. Here, my lord, the virus of the Rule 37 was challenged. So which also mentions about corporal punishment, my lord.
Rule 37 of?
My lord, this is Rule 37 of the Delhi School Education Rules 1973, my lord.
What did it say?
My lord, Rule 37, if I may read, which is in para 2, my lord. Para 2, the next page, that is page 457. Rule 37, my lord. Forms of disciplinary measures.
Yes.
So these were the conditions, my lord. Number 1, the following shall be the disciplinary measures which may be adopted by a school in dealing with A. All students, detention during the break or neglect of classwork, but no detention shall be made after the school hours. Number 2, corporal punishment. Students who have attained the age of 14 years. Fine, expulsion, rustication. Number 2, for avoidance of...
What for you are reading this? What relevance it has now?
My lord, only with regard to corporal punishment, my lord.
But then why you are coming to B, this and all?
My lord, 4A. Corporal 4A.
A concerns all students.
No, my lord, 4A. Corporal
students?
punishment may be given by the head of the schools in cases of persisting impertinence or rude behavior towards the teacher, physical violence, intemperance, and serious form of...
in my favor.
No, my lord. These were the provisions again which the Parents Forum had approached the Honorable Delhi High Court. My lord.
Against this provision, and Delhi High Court had struck it down.
Grounds taken were that, my lord, they are violative of the Articles 19, 29, 37, 39 and 40 of the Constitution, my lord. My lord, the finding of the Honorable Delhi High Court, my lord, which is at para 468, my lord.
What relevance it will have here in this matter?
Lord,
that is where a rule allowed corporal punishment.
My lord. So this was held to be
Here
violated.
It is not the
my lord.
case. Here it is not the case.
My lord. If I am only allowed to read the finding, my lord, of the Honorable. But here, my lord, they have in detail, they have dealt with a lot of factors, my lord. If this Honorable Court allows, I may go through, my lord.
Yes. Read out which para you are reading?
My lord, page 461. In fact, it starts from 460, my lord.
What is the relevant part?
I may be allowed to... First, I will take, my lord, to Article 37, that is page 461. State parties shall ensure that
No, that is certain provision of certain rules.
Yes, my lord.
Then what do you have to do here? This rule is not applicable here.
My lord, no child shall be subjected to torture.
No, whether this rule applies here in the state of Meghalaya.
No, it does not apply.
Then
that of course.
Why? That of course means what do you mean by saying that of course?
My lord, because my learned senior had over and again stressed on the corporal punishment issue. My lord.
See,
this is just to cover that part.
Say basing on something which is applicable here. You are reading out some rules and all which is applicable to some other state. Not here.
No, that is admitted. But that is exactly why I had stated
problem,
before, my lord, prior to citing this judgment, my lord, that this is, of course, this is the case of Delhi. But my lord, my senior had laid stress on the corporal punishment issue, my lord. So only for that aspect, my lord, just
he has made a conjoint reading of section 88, 89 of the IPC and 75 of the Juvenile Justice Act to show that section 75 will not be applicable to a teacher. Now that is your reply is expected on that thing only.
My lord, my respectful submission will be, my lord.
Now, whether section 75 makes that corporal punishment an offence under the Judge Act, and if it is made, will it be applicable to teacher?
Whoever having, my lord, what the definition says, whoever having the actual charge or control over the child. So, my lord, why when a child is in the school, my lord, it is in my respectful submission, my lord, the school authorities are definitely in charge of the child. My lord. Whoever having the actual charge or control over a child.
Does it speak about corporal punishment? Read it. Come to section 82 then.
Corporal
section 82
punishment.
Specifically deal with corporal punishment.
Any person in charge of or employed in a child care institution who subjects a child to corporal punishment with the aim to discipline the child shall be liable on the first conviction to a fine of 10,000 rupees, and for every subsequent offence shall be liable for imprisonment.
Don't you think that section 82 is more applicable than the section 75? And the session just order by which that 82 has been dropped, you have not challenged that order.
My lord, the state has not challenged this order. My lord. That is there.
Now, which is section 75 is applicable here?
Only to the extent, my lord, where it says
as
punishment.
per the
for
Judge Act,
cruelty.
corporal punishment becomes punishable only in case of any person in charge of employed in a child care institution.
My lord.
Now, Sessions Care has given a categorical finding that school doesn't come under that definition.
My lord.
Then?
Of course, that is not challenged by the
Yes.
state.
Then?
So, that not being challenged, my lord, that position would stand.
Then how section 75 will remain then? Then your reference to 224 is irrelevant. If you admit that part, then 224 has nothing to do here.
My lord, of course, as far as relevance is concerned, my lord, section 82 is more relevant actually, corporal punishment. But of course, that is a defect, my lord. Now that of course cannot be, as far as the state, since the state has not challenged, my lord. But even in the Honorable Supreme Court judgments, my lord, they have stated the judgments which is cited, my lord, everywhere it is stated where there is, the act is bona fide and good faith and for the good of the child, my lord. Now that factor of course is not argued here, my lord. So as far as the good faith is concerned, my lord, this can only be established only by a trial, my lord.
Then let us say it is in bad faith. Let us assume that it is in bad faith. Let us say that there is this thing. How that will come under section 75.
My lord, of course, I have some other judgments, but of course,
if it is not relatable to the issue here, then those judgments.
my lord, certain issues have been covered, my lord. Here, my lord, the charge was dropped against one of the teachers, but it proceeded against the other, my lord. Punishment for cruelty. 75. My lord, this is again relating to Kerala, my lord. This is JGAV, Petitioner versus State of Kerala.
See, your Delhi High Court decision relates only to a thing where a rule permits corporal punishment. It was held that it is against the law. So, whether corporal punishment has been awarded in accordance with law or not, that is not the question here. Whether corporal punishment is a cruelty to child.
My lord.
Whether awarding corporal punishment would amount to cruelty to child.
Yes, my lord.
How?
Because it will depend on the intention, my lord.
How?
Then intention will decide.
So why the law has why the Juvenile Judge Act has
my lord, let's
differentiated it. Say like punishment for cruelty under section 75, punishment for corporal punishment section 82. Why that has not been clubbed together if it is always cruelty?
No, my lord, it will not always be cruelty, my lord, but the intention behind
When
is
it will
important.
be cruelty and what will not be cruelty?
But only the intention will decide, my lord. Whether it is the intention
to cause harm will be.
My lord, if there is an intention, a malefied intention or an ill intention is there for committing a certain act, my lord, and where it is a question of purely a question of discipline, it would be a different matter, my lord.
So section 224 will come under purview of section 75 of the Judge Act. That is what you want to say,
my lord. That will come. In fact, my lord,
your
even
answers
82,
are,
even 82 comes.
Your answers are neither here nor there.
My lord, even 82 comes, my lord, because that is more relevant. The corporal
82 is gone. Forget about 82. 82 you have not challenged.
But my respectful submission, both would be covered, my lord. 82 as well as, my lord, corporal punishment means subjecting a child to a child by any person to physical punishment. Now 75 also what it says, my lord. Whoever having actual charge or control over the child, assaults. The question of assault is also here, my lord.
What is the heading? Punishment for cruelty to child.
Punishment for cruelty to child, my lord. Where this is neglect in a manner likely to cause such child unnecessary mental or physical suffering shall be punishable with imprisonment for a term which may extend to 3 years or with fine or of 1 lakh or with both. So, my lord, even if 82 is gone, my lord, here also, my lord, the punishment is definitely there. Punishment has been laid down, my lord, even for cruelty. Even assuming that there is no corporal punishment.
What about then section 88, 89 IPC?
My lord, as far as section 89, 88, 89, my lord, in the instant case, no charge has been framed under that, my lord, these sections.
What this man is saying? Have you ever bothered to open the book and read it? Sure.
No, my lord, I understand what has fallen
You
from
have
this
not
honorable
understood
court.
anything. Please avail services.
My lord, kindly see this judgment of this Kerala High Court.
This case of Kerala High Court also in my favor.
But my lord, charge has been dropped against one, but it is to proceed against the other, my lord.
Under
where
what
a
section?
student has been subjected.
Under what section?
My lord, here section 75 is there of the Juvenile Justice Act.
Okay. What is the relevant part?
Can you give me a copy of
That is a recent judgment, 2020.
Yes, my lord.
Yes.
If
yes,
my lord, I am allowed to read from para 4, my lord.
Para 4.
This is the
yes.
gist of the allegations.
Yes.
The gist of the allegations in the impugned annexures A and B criminal proceedings are as follows: that the minor son, hereinafter referred to as the student, of the second respondent, the then aged about 17 years, was studying in standard 9 of the school. standard 11 of the school in which the accused number 1 is working as laboratory assistant and the petitioner herein was working as physics teacher. That on 30/9/2019 at about 1:30 p.m. when the student had gone to the physics laboratory in the school, the petitioner, that is A2 accused number 2, had examined the physics practical records of the student, and she found that the student had not completed the record work and had questioned him as to why he did not do it, and then the student had told the petitioner that his physics record book was with the petitioner, who is his physics teacher from 25/9/2019 to 30/9/2019, and that he had collected it only on 30/9/2019, and that is the reason why he could not complete the record work. That thereafter the first accused, who is the first lab assistant, had also checked his physics records, and on finding that he has not completed his assignments in the records, he got enraged at him without any reason and had threatened the student in an extremely cruel manner, and that both the accused persons, the then instructed accused person then instructed the student to go out of the lab and complete the record works. That when the student was being caned by the first accused,
who is the first accused?
First accused is the lab,
not a teacher.
Thereafter the first accused, who was the lab assistant.
Then in this case, against whom the proceeding has been dropped?
My lord, the teacher, the reasons for which the proceeding was dropped, my lord, is because, my lord, if I am allowed to read just this paragraph, my lord, that when the student was being caned by the first accused, the petitioner, that is the accused number 2, had not taken any steps to interfere in the matter. That was the allegation, my lord. So this is the reason, my lord, one of the reasons for which the proceedings was dropped against the petitioner number 2, that is the teacher, my lord. So, that the first accused had thus cruelly punished the student.
That's okay. Then which way this case comes to your?
My lord, only to draw that inference, my lord, that if punishment is given, my lord, then the case can proceed.
No, the accused is a lab assistant, not a teacher.
My lord.
Then?
Here accused is a lab assistant, I understand, my lord. But here the allegation, of course the teacher factually, my lord, the teacher did not do anything. The grievance of the complainant,
teacher is not into picture in this matter.
The grievance of the complainant here, my lord, was basically that the teacher did not interfere when this kind of treatment was being.
So that means you are placing a case where lab assistant is involved.
Yes.
So it has nothing to do with teacher.
No, but of course, my lord, nothing to do with teacher. But my lord will kindly see on what ground the charge is dropped. The charge is dropped on the ground that teacher had no role.
Can I read paragraph 14 of this judgment, Your Lordship? If he permits me to read.
Yes.
Paragraph 14. I think my colleague.
Paragraph 14 is of course finding, my lord.
After hearing both sides, though I don't have the copy of this order, but still, after hearing both sides and taking into account the totality of the facts and circumstances of this case, it cannot be held for a moment that any of the vital ingredients of Section 75 of the JJ Act be disclosed as against the petitioner to the extent the allegations are made against her. She is a teacher.
Exactly.
This court is now concerned only with this issue as to whether any offence is disclosed as against petitioner number 2. He is a lab assistant. And none of the observations or finding can be construed as having any effect as the alleged act of the first accused. The learned counsel for the second respondent has a specific case that the first accused, who is the laboratory assistant, is appointed in non-teaching post, and that the first accused cannot claim the immunity of being a teacher. This case is my favor.
Probably he has not gone through. You see, like
no,
nothing has been done.
My only why I draw attention of this honorable court is.
Have you gone through the part which has been received?
Yes,
then The immunity of a teacher, that is main thing.
My lord.
Then?
That is there.
Again, he says that is there.
But my lord will kindly see.
You are so casual in your approach.
No, my lord.
You do not know.
Here the situation, my lord will kindly appreciate. The situation is different. The situation is different, my lord.
Beating around the
Here
bush.
no corporal
This
punishment.
decision will go against you now.
No corporal punishment was meted by the teacher, my lord.
Now, whether the corporal punishment can be equated with the cruelty which is there in that thing, enumerated in section 75.
My lord,
My
for
colleague
any
was saying that I did not say anything on the merit of the case because my colleague did not read my petition also. At paragraph 11 of my petition, I have clearly said that the aforesaid legal infirmities, that is what I have raised, and basic jurisdictional issues are prima facie born of the record of the case and not result of any factual dispute being raised by the petitioner accused. I'm not talking about my innocence or anything.
That is exactly, precisely, this court told him that let it be treated as a, say, allegation. As
let's say I have done it.
Say it is not bona fide. That is what. Now, I do not know where this is a problem, you know, like this is a real problem. And if you without any assistance, it becomes difficult for the court. It's really, it becomes really difficult.
My duty here is to assist the court. I have done my level best to bring the
definitely
actual, the law.
If there at all exists any counter version of that, the court is interested
It
to
would have
know
been
that.
very interesting for us
It is
also.
very much interesting, you know. But then I do not know what to do. Say like, it's it may not be proper on my part to comment sitting here, but then something is not.
So we rest our submission, Your Worship.
Lord, as far as 75 punishment for cruelty to child, my lord.
Again and again. I was saying.
Lord, my respectful submission that will remain, my lord. Now it is for the petitioner to prove in the.
What about section 88 and 89 IPC?
My lord, that will also have to be proved, my lord.
Probably, have you gone through those? I don't know. Making absolute mockery.
Taking the code for granted is not my job.
No, Lord, that is not the case, my lord.
Very, very casual in their approach.
Now here it says, my lord, 89, act done in good faith for benefit of child or innocent by consent of guardian, my lord. What the proviso says, my lord?
Now, one thing, Mr. Kinta, you come to the very judgment which he relied on at page 8.
Corporal punishment.
Just last few lines, you say. Page 8 of the judgment. Come to the last but the sixth line. Sixth line from the bottom. Since the impugned action of a teacher.
Huh?
Since the impugned action of the teacher.
Page 8.
Page 8.
Of the case Matthew E.T.
Yes, Matthew E.T.
1, 2, 3, 4, 5. Which one, Your Lordship? It can be seen from a mere reading of the say above.
My Lord, in para 6, my Lord.
See, this page 8 starts of section 82. Have you got it?
Yes, section 82 corporal punishment.
Of section 82 of Judge Act. That is the wording.
Ah, yes, yes.
Now come to the down this thing below. Sixth line from bottom. Since the impugned action, it starts with sixth line from the bottom. See, after section 88 of Judge Act, and then since. Yes.
Itu ke dia tu. Kawan kan can be seen from a mere reading. Itu. Ya, kenapa?
Could you look at the line?
Let me read the entire portion.
No, just this part too, Jesus. Since it is not there in your copy.
It's, same thing, but you're getting a little bit harder. Yeah, we got.
Can we read it again?
We have to read it again.
Just see, since the impugned action of the teacher, from there only.
No, we have to read before this also.
That will be okay, but then just come to those.
Let's come from a little bit ahead. There cannot be any doubt. You got it, Your Honor? there cannot be any doubt.
So what is the line? You're reading from which page?
The same thing, the same page.
Page 8.
Let me start again, Your Honor. It can be seen from a mere reading. Let me start with this one from the previous page. Yes. It can be seen from a mere reading of the above said provisions of JJ Act that the legislature has made the offence of corporal punishment punishable in terms of section 82 of JJ Act only. Only if it is inflicted by a person in charge of or employed in a child care institution.
Not in your case. You are not there, you see.
The legislature has consciously and guardedly, on account of its legislative wisdom and policy, has mandated that in such a scenario, the act of corporal punishment as envisaged in section 2, bracket 24 of the JJ Act is made a punishable offence as per section 82 only in a case where the impugned act is done by any person or person in charge or of or employed in a child care institution as envisaged in the above said provision. Hence, it is clear, like the daylight, that the legislature has not made the act of corporal punishment punishable where it is inflicted by a teacher.
Yes.
The rationale in excluding the teachers from the purview of section 83 of the JJ Act is presumably on account of the above said well-known common law principles of loco parentis. There cannot be any doubt that if the impugned act of the teacher broadly comes within the contour of section 2, bracket 24 of the JJ Act, and thus it satisfies the ingredients of corporal punishment as envisaged in the section,
Yes.
But then, the Parliament has specifically excluded the teachers from the purview of punishability of such an act of corporal punishment, as can be seen from the provisions contained in section 82 of the JJ Act. Since the impugned action of the teacher in such a case in pith and substance, which discloses corporal punishment as per section 2, bracket 22 of JJ Act, and as the said act done by the teacher has been excluded by the Parliament from the purview of section 82, it cannot be said that such teachers can otherwise rope in within the contour of section 75 of the JJ Act. This is what...
Please. Again, go through.
Of course. If the so-called penal measures taken by the teachers grossly exceeds the permissible proportion of a penal measure that can be taken by a teacher for disciplining the pupil, and the act otherwise discloses a serious offence as per section 324 grievous hurt or simple hurt, then of course it might stand in a different footing.
Yes.
And those are all matters of question of fact,
yes,
which have to be assessed in the matrix of the facts and circumstances of each case.
So that is what.
So, Your Honor,
that part goes against you.
No, Your Honor. Your Honor will have to read and reread again. Your Honor will. It is so clear like daylight that if section 82 is not applicable, then the question of roping in section 75 is not applicable.
But then the last part again, of course, if the so-called penal measures taken by the teacher grossly exceeds permissible proportion of a penal measure,
okay,
that can be taken by a teacher for disciplining the pupil, and the act otherwise discloses a serious offence as per section 325 grievous hurt or simple hurt, etc., then of course it might stand in the different footings.
Okay, but not under JJ Act. This is not a matter.
Then what about the 375? 375 speaks about assault.
Look at the finding, Your Honor, at para 11th. You have to read this judgment in toto. Let's read para 11 again. Your Honor is trying to read between the lines.
No. I'm just reading the last part of this observation, which has been made in paragraph 6. Now, it has basically excluded a teacher.
Excluded.
For being...
Because Parliament has excluded.
Proceeded with...
When Parliament has done it.
Okay. For taking a corporal punishment.
Yes.
That is totally exempted.
Huh.
But even then, the extent to which
Yes.
You see, a punishment is inflicted. That becomes a question of concern. Now, that is where it has been said, if it exceeds the permissible proportion of a penal measure.
Yes. Then
how do we determine that at this stage?
What is the case here? The case here is that the GG Act is not applicable to a teacher. This entire judgment is on that. In the event there is a serious, where the serious offence has been committed, all those exceptions under section 88, 89 will not be applicable. That is the meaning of this. Because the later part of this...
Come to para 11, what you say?
Para 11.
Yes.
The above said act of the accused as allegation in the FIR cannot be said to be involving intentional use of force in order to commit an offence or intending by such force to cause or knowing it to be likely that by the use of such force he will cause injury, fear or annoyance to the person to whom the force is used as envisaged in section 350 of the IPC.
So that is a factual observation.
Yes, let me... such an act of the accused should predominantly as seen as an act on the part of the teacher to correct their people, which inherent has been conferred by general law on the teacher by the well-known common law principles of loc parentis. Therefore, it will not be legally correct to contend that such an act of the petitioner accused would constitute an act of assault as envisaged in section 75 of the GG Act.
That is entire finding is factual.
Yes. Now the judgment
see, that means this finding came on the backdrop of the FIR which was filed in that case.
I have indicated, Your Honor, that the story in this case is akin to my case.
But then it is left on the factual aspect, isn't it?
I have...
so that is where you see...
I have indicated, Your Lordship, that the teacher in question, the petitioner, irrespective of what has been done or not done, I have not raised that factual aspect. The fact remains that I say that I cannot be roped in for an offence under section 75. Now the lower appellate court has rightly held that section 82, because if you read section 2, bracket 24, it has to be read conjointly with section 82 of the GG Act. Now the court has rightly held that this is not an institution under GG Act. So 82 has been dropped.
Now we are
if
not
that
on,
is the case, then
now we are not on corporal punishment. The corporal punishment is gone in view of the exclusion of section 82, dropping of section 82.
My case is very...
Now what remains is that whether the FIR discloses an offence of assault or not.
My case before this court, I have indicated, I have not gone into the factual aspect. I have come straight on the law point that section 75 of the GG Act is not attributable to me as a teacher. That's all, Your Honor. I rest my submission.
All right. My Lord, para 6 of the said judgment, my Lord, which is referred by my senior.
Yes. Yes.
So, my Lord, it is now well settled by a series of rulings. So, these are the rulings, my Lord, that in a case where a teacher in course of imparting education...
Which page you are reading?
My Lord, this will be
section 6 is para 6 is very, very big. Which page?
My Lord, starting from para 6. My Lord.
Yes.
If I may read, my Lord.
Yes.
So, my Lord, here it is now a well settled. It is now well settled by a series of rulings. My Lord, these are the several rulings. So and so, etc. That in a case where a teacher in course of imparting education beats a student with bona fide intention to maintain discipline. Now, this exemption is there only when there is a bona fide intention, my Lord. Then, as a teacher is given the implied consent.
See, bona fide intention means when it's a case of corporal punishment.
My lord.
Confined to that.
Then as a teacher is given the
Now,
implied...
what would constitute a corporal punishment and what would become an assault? Which way to be determined?
My lord, that is a matter
Now,
of
person
evidence.
was charged under 323 and section 75.
My lord, that, my lord, in my respectful submission will only be a matter of evidence, my lord. It can be established only through evidence, my lord.
Where is the definition of assault? C51 IPC.
Yes, my lord. Whoever makes any gesture or any preparation intending or knowing it to be likely that such gesture or preparation will cause any person present to apprehend that he who makes the gesture of preparation is about to use criminal force to that person is said to commit an assault. Mere words do not amount to an assault, but the words which a person uses may give to his gestures or preparations such meaning as may make those gestures or preparations amount to an assault.
Yes, anything more?
So, my lord, it further says, so my lord, most important is that bona fide intention, my lord.
You have said it.
Then, as a teacher is given the implied consent, so only at that point, my lord, it will be implied that a consent is given by the parent to enforce discipline.
At what point? That point means?
My lord, that
Once
in
you-
case where a teacher in course of imparting
When you
education,
send your word to a school,
my lord,
that is implied that you have consented that the child be disciplined
my lord.
by the teacher. That is implied.
But definitely, my lord, I will not send my child to school for being subjected to any form of, my lord, assault or punishment, unnecessary corporal punishment, etc., my lord, or assault for that matter. Of course, I would send my word to school for proper education, but at the same time, I will also expect that, my lord, my child would receive proper treatment, my lord.
To what extent section 88, 89 will apply to the teacher?
My lord, as per the judgment,
Unlike, say like a surgeon,
my lord,
where the
here-
example has been incorporated.
My lord, here it speaks of a surgeon, my lord. Of course, the judgment which is cited by my senior, my lord, it says that some special exemptions are carved out for the teachers, my lord. That is what the judgment says, my lord. For example, section 79, 89, 319, and 95 of the IPC, my lord. These are the special sections which are carved out. Now, my lord, but as far as this instant case is concerned, my lord, this instant case, my lord, charge has been framed under, my lord, the
Charge not framed. Charge not yet framed. So charge has been
Charge sheeted. It is charge sheeted.
Charge sheeted.
Charge sheeted, but
Charge
not-
sheeted.
charge not framed.
So my apologies, my lord. So charge sheeted under these sections, my lord. Sections 325, 323.
Otherwise, by limitation. But then, if it comes together with 75, then it will stay.
Yes, my lord. Charged under section 323. Section 323, then section 75 and 82 of the Juvenile Justice Act. 75 and 82 of the Juvenile Justice Act. So
82 is gone.
Yes, my lord.
323 IPC is there, isn't it?
323 and 75 remains, my lord.
Okay.
So, my lord, only before concluding, my lord.
Yes.
This court, the appellate court, have dropped that section 82 because saying that it's not a school, it doesn't fall under 82. But when it came back to the trial court again passed an order for charge to be framed. That's why if we go through the petition, again charge to be framed under section 75, 82.
82 will definitely not remain. That is for sure.
That is. I'm here on a different
my lord,
footing. I'm not on the. If I'm here on the corporal punishment, I think I've got dozens of judgments. I'm not here on that. That's why I've said I'm not on the factual aspect. I'm here on that point.
No, now after section 82 has been dropped, the question of corporal punishment doesn't remain here. Only what is to be seen, what is the applicability of section 75, 370.
My case is that section 75
70.
cannot be made applicable. That's all.
That is what it is.
That's my case.
And my lord, here also this
My colleague
judgment.
is on and on beating around the bush. The same, my
But the
decisions, the court will read at leisure. He's trying to read my. He brought a judgment. Is also again in my favor.
My lord, that is only I tried to, my lord, draw an analogy stating, my lord, that where that was a case, my lord, where the
You are
teacher,
saying that corporal punishment is banned. Okay, even it
My
is
lord.
banned also. What?
No, my lord, here in that judgment was brought before this honorable court only to only to take a reference, my lord, that that was a case where the teacher had not done anything at all. It
And
was
then-
the lab assistant who had done anything.
Then what happens if you take into consideration section 2 of the Judge Act? Can you say that the child was under the care of the teacher?
My lord, from the reading of the section, my lord, in my respectful submission, my lord, if a child is, a ward is sent to the school, my lord, at least for that period, definitely under the care of the school, my lord.
This you will say on the basis of what provision?
My lord, I'll rely on
The act shall apply to all matters concerning child, so and so, including. So it doesn't limit anywhere, isn't it? It doesn't exclude anything. It doesn't say only this. It is applied to all matters concerning children in need of care and protection.
my lord had also rightly pointed out, my lord, that as far as the extent, the permissible proportion of penal measures, my lord, the teacher, to what extent the teacher has done. So, my lord, in my respectful submission, that will be only clarified only through evidence, my lord.
Oh, it's already here, simple injury. You are not disputing anything on that. What's your right, Lordship?
Yes.
Good day.
Nothing more.
Lordship will reserve for judgment this matter.
It is. Hearing concluded. Thank you.
Good day.
All right, my lord.